Welcome to Milford's July 17, 2018 Planning and Zoning Board meeting. If you can, please rise for the Pledge of Allegiance and a moment of silence. If we can we have roll call from my left?
Good evening, I'm Brian Collegian.
Nancy Austin.
Scott Marlowe.
Tom Panzella.
Bob Sadie.
Peggy Kearney.
And I'm Carl S. Moore, acting chair in place of Jim Quish, who's not here this evening. We are also represented by Meg Green, secretary and board clerk, and David Sulkus, city planner. And our first order of business on the agenda, which is old business, we don't have any. So new business, 32 Gulfview Court, R-12.5, petition of Duran Munzer for coastal area site plan review on map 37, block 588, parcel 5C, of which Duran Munzer is the owner.
Hello. My name is Doran Munzer. I own 32 Gulfview Court. I've owned it for like 3 years. There's an existing house on there with a full basement, which everything is off the FEMA line, and we're just trying to get it approved. We're going to demo the house, and I'm going to construct a new house on the existing footprint of the old foundation. And therefore I applied for a CAM approval. I think I'm not technically inclined, so I got my surveyor here. I think maybe you should probably...
Yep. I'm also here to answer any questions, but basically we're...
Please state your name, please.
Sorry. My name is Fred D'Amico. I'm the engineer for the project. Office at 9 Park Road in Oxford. Basically what we're doing is, again, as Doran mentioned, there's an existing dwelling on the property. We are going to remove the dwelling. We're reusing the existing foundation, and there's going to be a small addition in the back and a small addition in the front. But basically it's essentially the same foundation. The entire property, the entire dwelling and improvements will be outside the 100-year FEMA flood line, but because we're close to the Gulf Pond, we do requires a CAM report.
Is that all?
That's it. I'd be glad to answer any questions.
Any comments from staff?
You have my report. It's missing one word, and I'll tell you what that word is when we get to it. I'll just read to you. It's brief. The applicant proposes constructing a new 2-story single-family dwelling. Inland Wetlands has noted the plan should be amended to show erosion and sediment control per the 2002 DEP manual. The city engineer noted greater detail is needed to be certain the precise location of the limits of the FEMA special flood hazard area. Addressing concerns of both departments can be made as a condition of approval. There appears to be no adverse, and this is a word that's missing, environmental impact with the proposal, and it appears to be substantially zoning compliant.
Thank you. Questions from the board? Yes.
Mr. Moore, through you to the applicant. On the drawings, I didn't see the total height of the structure, and I didn't see existing grades on the plan.
The existing grades, we did revise the plans and brought new plans in. There should be, the new plan should have the existing grades, because that was one of the comments that Mr. Pedlewski had, that we did not have the existing topographic survey on there.
And it should be on there.
He might have a copy of the old one.
Maybe the old one?
How high is it over the
I
drawings too?
have a copy,
Or they have them too?
and this is it.
No, of the building plans,
Yes, I do. It's in my car.
because that shows the elevation, don't get it yet.
Okay.
There's, yep, the actual elevation 12 is basically, well, I have it highlighted in yellow here, but it basically goes right around the house. And that elevation, that contour line 12 happens to be the 100-year flood zone also.
And everything is behind that flood zone.
And the elevation of the building?
The elevation of the building is actually going to be, I believe it's like 17, it'll be 17, right around 17.
No, I should say roof,
Oh, the height of it?
yes.
It's 2 stories, so
One and a half story.
it's one and a half stories.
Story. It's a ranch with just a small little, I mean, I've got all the plans.
Well, I have the plans, and I do see some heights here, but like in between the first floors, the dimensions are plus or minus, and
Doran?
I believe it's approximately 25 feet
Okay.
from the first floor.
thank you.
Any other questions from the board? Seeing none, do we have a motion?
I'll make a motion to approve.
We have a second?
Second.
We have a vote. All in favor? All opposed? The motion carries.
Thank you.
Thank you very much.
Our second item on the agenda is item E, public hearing, continue from June 19, 2018, 622 Gulf Street, R-18, petition of Kevin Kirsten, Esquire, to create a 4-lot subdivision and coastal area site plan review on map 28, block 520, parcel 26, of which George H. Ward is the owner.
Good evening.
One second, please.
Mr.
I was
Panzera, please.
not at the 619 meeting, but I reviewed the hearing, and I'm fully up to speed as to what was going on.
Thank you. Thank you for putting that on the record. Mr. Chairman, members of the board, my name is Kevin Kersade, and my office is at 3 Lafayette Street here in Milford. With me tonight is Mr. Ward, the owner and the applicant, and Matt Duche, the engineer from Malone and McBroom engineering firm. At the last meeting, we went through a more extensive presentation. I brought the same materials in case anybody had any questions from the last meeting or in case somebody had reviewed it and wanted to ask some questions tonight. I really just have 1 or 2 comments, and then Matt Duche was going to answer a question that Mr. Grant had posed about the landscaping. And I had also prepared a slide to answer a question Mr. Grant had asked about the number of waivers we were asking for, what they were specifically waiving, and what lots they were with respect to. So I have a slide for that. But my recollection from the meeting was the board had a question, which is a primary question, which is why it's up there on the slide, as a slide, was does the board have the authority to grant waivers of the subdivision regulation? So I wanted to answer that question first. I had mentioned last month, I just didn't know if I was clear enough about that. So the board's authority to grant waivers comes from Connecticut General Statute 8-26, where it specifically authorizes boards, planning and zoning boards, to grant waivers of subdivision regulations. And then you also have in your Milford Subdivision Regulations, section 6.4, a regulation that seems to stem from the state statute that basically says under certain conditions, as long as the board finds that the subdivision requirement isn't requisite or in the interest of the public health, safety, and general welfare, and you state on the record the reason for waiving those subdivision requirements, that you actually do have the authority to do that. to go to the next point, these are the waivers we're requesting from P&Z by lot. And I went over this today in preparation for the hearing, and I kind of matched it up, well, I did match it up against Mr. Sulkus's administrative summary, where he says that the subdivision application's not in compliance with 3.2.10 and 3.2.7. So for lot 1, you can see that we're asking for a waiver based on Mr. Sulkus's memo of 3.2.7 because there's a slight bump out. The lot's not, and I'll go back and show you the lots in a minute. It's not a 100% rectangle, but the language basically says generally rectangular in shape. It doesn't say a perfect rectangle. So same thing for lot 2, because lot 2 and lot 1 are adjacent, so the bump out into lot 1 or lot 2 impacts the other lot, obviously. Then lot 3, we have it's the 25-foot wide access that we had talked about, and David and I, Mr. Sulkus and I disagree with each other about what the reg requires or whether we can subdivide these lots with the existing accesses. And then lot 4, that is kind of a flag-shaped lot, and so that's why we have 3.2.7, because it's not generally rectangular in shape, that lot 4, and it's one of the rear lots. Lot 3 and 4 are both rear lots. And then subdivision regulation 3.2.10 for that lot, which is also the 25-foot wide access way because it's a rear lot. So those are the waivers we're asking for. The board does have authority to grant them. When I had given the presentation last month, I had explained the history of the lot and how it had been developed over time, and it has the existing rights of way that are deeded, and I had given the board copies of those deeds, and I have those deeds again tonight. So I want to keep it clear and concise as possible, but I do want to let the board know that I disagree that we need some of these waivers based on my understanding and reading of case law and what a property owner is allowed to do with their subdivision. But regardless, we're asking for them tonight because Mr. Sulkus has raised them in his memo. There's a case from 1924, and I'm not going to bore the board with all the details of it, but it essentially says that you can, it hasn't been overturned, it hasn't been overruled. It says that a property owner who subdivides the land can access that land from existing easements or rights of way, regardless of whether it doesn't have any discussion about what the width of the right of way is or anything like that. So, and I had mentioned we had an opinion from CATIC, Connecticut Attorney's Title Insurance Company, an attorney there, Attorney Dick Selman, which I believe I put a copy of the email into the record, who said that if you include on your map and a declaration of easements that are internal to the subdivision, they would insure the lots as buildable lots. So I think that that's a third-party opinion on that that verified, and it's based on that case I just mentioned. So I don't want to go too much farther into that. I'm more than happy to answer any questions about it. We think that based on the way that this lot was developed and the use of the lot over the years, I want to go back to the maps so you can understand the before I go back to the maps, I had mentioned last month that there was a fourth house on this property at one point in time. It was called 628 Gulf Street, or that's what was in the files. That was a previous fourth house. It burned down in the 80s, and Mr. Ward didn't rebuild it, but he never intended to abandon that use. So I'm going to click back to the lots so you can see what we're talking about with the bump outs. So this is lot 3, lot 4, and I don't know if that's lot 2 or lot 1. That's lot 1 and lot 2. So if you see this bump out here, and that's based on the existing house so that the setbacks are continued to be met. So this property line, as you can see, is not a straight line, so it's not generally rectangular in shape. My opinion is it is generally rectangular in shape, but that's for it's your discretion how you interpret your own regulations. This one is, oh, sorry, Mr. Sullivan, if you can see that. This lot is also, we're asking for a waiver of 3.2.7, which is the rectangular in shape provision. As you can see, that's just the way the lot was created. There's more land, there's more trees and landscaping available. But we're asking for a waiver. This is what the property has been, since long prior to the subdivision and zoning regulations. And then the access ways were, I think these are like 12 to 16 feet wide in the back, depends on what area of the road you're in, and the rights of way are deeded back and forth between the property owners, and the same thing here over Mr. Luparella's property, who I'll talk about in a minute with respect to this property, and Tom Lynch was here last month raising some questions. This is 12 to 16 feet wide, this existing access way. So those waivers are requesting from the rear lots, actually, only are the 25-foot wide access way in the back, because we don't have that existing access way. The neighbors don't want that access way increased. Mr. Ward has no intention of increasing it, the width of it. He can't legally do it anyway unless all 4 or 5 of the neighbors agreed to that, because that back country road or driveway goes out to Old Field Lane. What we did do, however, is where we could, we made it 25 feet wide. So there's a 25-foot right-of-way over Lot 3 into Lot 4. So where we could adhere to the 25-foot wide accessway requirement, the plans are designed that way. Mr. Lynch was here last month. I've had an individual meeting with he and I about the access over Mr. Luparella's lot. There's been 2 joint meetings of the property owners, including a third property owner, Mr. Joe Bleckfeld, who came and spoke in favor of this application last month, who lives over here. The meetings are productive. The discussions are ongoing. We've presented a couple of different plans as far as moving or relocating this existing accessway that's been in place since the early 1900s. It actually flowers out. It goes this way, and it's not shown here, but the deed actually allows it to go this way. This used to actually be a road that went all the way through the property and all the way over here to Old Field and back down to Old Field Lane. The road's been, it was a private road, wasn't a public road. But Tom Lynch called me today. He said he wasn't going to be here tonight. He did say I could represent to the board that based on the good faith that Mr. Ward has shown and discussions have gone on, they just met out at the property on Friday with John Malone from Malone and McBroom to try to stake out where the drive could be. So Mr. Luparella, when he replaces his house, right now it's a vacant lot. He has more options about where he can place the house. Mr. Ward's trying to walk a fine line between satisfying Mr. Luparella so he doesn't come and object to this project or appeal the approval, and Mr. Joe Blickfeld's property over here, and any negative impact that a new house here might have on Mr. Blickfeld, who's already stated his support of this project. So there's a lot more negotiations and discussions that need to go on with that. But Mr. Lynch has represented, he said I could represent to the board tonight that his client does not have any objections to the application tonight. And then I think one last thing, and then I'll submit just some documents to make sure that they're in the record. With respect to Tom Lynch's claims, Attorney Lynch's claims, and any talk about private access, and you can't grant, I think there's a couple of mentions in Mr. Sulkas's memo about you can't grant, there's a legal question of whether, can you grant the subdivision approval based on these private access easements? That case I mentioned says yes, you absolutely can. That's number one. And number two, that's a private discussion between property owners. That's not a zoning or a subdivision issue for the board to decide. So, and the reason for that is because whether somebody's overburdening an easement or not using it properly depends on many different circumstances, depends on what was in place at the time, depends on the language of the deed, and that is really up to, if the parties can't work it out, that's really up for a judge to decide. So the board might not like hearing that that's not within their purview, but it's my opinion that that's a private dispute. I don't know if you have any questions for me. I wanted to submit copies of the deeds again, and our proposed declaration of easement, the email from Dick Selman at Caddick, a copy of the case just for the record, and the easements that grant the right-of-way between the property owners, and I could submit those now. And for the record, I did deliver to zoning a copy of the PowerPoint, a digital version of the PowerPoint last month, and I made a couple of additional slides, and I'll submit those digitally. And if nobody has any questions for me, I'll be followed by Mr. Duche, who wanted to answer Mr. Grant's questions about landscaping.
Good evening, everyone. For the record, my name is Matthew Shea. I am a registered professional engineer with Mylone & McBroom, and we're located at 99 Realty Drive in Cheshire, Connecticut. I don't have a lot of new information to present tonight. I just wanted to address one question that had come up at last month's public hearing, I think was raised by Commissioner Grant, regarding how are we satisfying the landscape requirements on this subdivision. So on the plan that you see on the screen now, you'll see a number of specimen trees. As part of our survey effort here, we did do a tree survey where a licensed landscape architect went out to the site, identified the species, and GPS located the trees that you see there on the plan. Typically, a tree is measured in what is referred to as DBH, or diameter breast height. So they measure it at breast height, the diameter of the tree, and that's what's recorded and depicted on our plans. The Milford Subdivision regulations, section 3.18, regarding on-site tree requirements, says that a minimum aggregate of 75 inches of tree diameter measured at breast height for every acre of site area is required. This aggregate shall be calculated and applied on a lot-by-lot basis. The minimum shall be met either through the preservation of trees or the planting of additional trees. So what we've done here is on our title sheet of our plan set, which everyone should have, we've broken out each lot and based upon the lot area and that 75-inch requirement per acre, noted how much diameter breast height tree is required on each lot, and then noted how we're satisfying that requirement. So that's on our title sheet, and then also on our plan set, sheet 7 is our tree protection plan, which again shows all the specimen trees on site, and then the ones in close proximity to the construction areas, and the ones to be protected because of that proximity. So our plans outline the number of trees to be saved, as well as the diameter breast height of those trees, and they show that we do meet the requirements of section 3.18 regarding on-site tree requirements. So I just wanted to clarify that for the record. If anybody has any questions about that information, I'll be happy to try to answer that for you. Seeing none, I'm going to turn it back over to Attorney Gersaden here.
Thanks. And that's all we had to present this evening. I don't know if what's up next for this.
So this is a public hearing, so if there's anyone here to speak, please follow the following procedures. If you wish to present any comments, clearly state your name, address, and the spelling of your name. Address all comments to the commission only, and please keep your comments to under 3 minutes.
Okay. My name is Tom Mealy. I'm the owner of 612 Gulf Street, which shares a little over 500-foot border with George's property on the top half of this map that you see there. The way this is currently drawn, the Lot 4 will now basically enter a small driveway at the end of my property and cross my front lawn and go down the road out to Oldfield Road. I invite any of you to come down and look at this alleyway that basically runs through there. It's a shared common driveway. It's private property. It's maintained by all the property owners along the way. And I'm not too anxious to add additional traffic into this roadway. It's fairly narrow. It's too narrow for 2 cars to cross. And I feel it's pretty well burdened the way it is. It appears to me that there is an access road going directly out to Gulf Street from this lot number 4, and I'm curious as to why that isn't going to be used and why we're going around about and taking a rather lengthy way out to Gulf Street. And that's my feelings on the subject. Thank you.
Anyone else here to wish to comment?
My name is Joe Blickfeld. I live at 650 Gulf Street. I've lived next door to this property for about 25 years, and for the 30 years before that, I was aware of it and delivered groceries to the various houses up there. I know you guys are stuck in kind of a tough situation with a 100-year-old piece of property and modern-day requirements. So it's kind of tough to meld the two together. But I would point out that on my way over here, I stopped by Seaview Avenue. And it's about a nice little beachside individual homes. And now we're just building right into it. Looks like about 12, either apartments or condominiums. And I'm quite certain, or actually I'm positive, they meet all the rules and requirements required of a subdivision or whatever they're doing. And I'm not here to judge them. I would only say they don't seem to be in the same character as the community they're located in, of beachside bungalows or homes, individual homes. Now we have an individual. Well, the other thing I would say about that is, it's just my guess that the development that is being done there is done to maximize the revenue they can get from that subdivision or whatever it is. Now we have here kind of a different zone. We have someone who wants to maintain the character of the community that he's in. And so it seems to me that that's a unique circumstance, and it's something that I can support. I live in the community. Does it do everything I want? No. I mean, I'd probably like them to donate it to me and I can make my lot bigger, but we know that's not possible. But to keep the character of that community, I think is unique. And George is trying mightily to get this done while he still has the health and the ability to do it. So I look at it as having a professional board that tells you what the facts are, but we wouldn't need your board if all we had was what are the facts. We need someone to use their judgment to say, under these circumstances, what is the best for Milford? What is the best for the community? So I hope you look at it in that area. And since I'm there, I do walk it pretty regularly. I look at that land. And my background is the military, and I know if you're going to set up an ambush, you better know how the property's set up. So I know there's hills and valleys and stuff in there that wouldn't jump right out on a map, but they exist. And the fact of the matter is that, taken all as a whole, I think it's a unique opportunity to keep the character of that property, and I'm for it.
Do we have anyone else who wishes to speak this evening? Seeing none, the applicant can speak to the comments presented.
Sure. Thank you. I'm referring to the police report, the traffic sergeant and the police commission report. There's on one of the pages, it references Lot 4. This is Lot 4's proposal, shows for the driveway to be the access way that leads to Oldfield Lane, which is here, and this is Mr. Mealy's property who spoke. using the above-mentioned 25-foot sanitary sewer easement is what the traffic sergeant's talking about. There's a 25-foot wide sanitary sewer easement. The right-of-way or the easement's not actually 25 feet wide, which is why we're having this discussion, but there is already a sanitary sewer easement off Oldfield Lane that comes in through here. You can see the dashed lines, crosses Mr. Ward's property and goes over to Mr. Luparella's property. So part of the easements that I had filed for the record include a sanitary sewer easement that Mr. Ward has given to the city of Milford and to it was Miss Ripley before Mr. Luparella owned the property, but it benefits this property so that they can have sewer. One of the other easements was a sidewalk easement for that wall that's over there. Mr. Ward had given the city a sidewalk easement as well. The traffic sergeant goes on to say there's concern for an obstructed sight line looking left toward Gulf Beach. However, the fix would be extremely involved in regards to removing land, trees, elevation, and current structures. So if you walk that site, or you drive that site, you can see that. An accident history going back to January 2011 shows no accidents at this location, nor am I aware of any issues raised by residents in the area. There will be no major impact to traffic volumes as this part of the project has only one additional residence. The speed limit on Oldfield Lane is 25 miles per hour. All lots in this proposal have adequate spaces for vehicles for the subdivision of the lots per Milford zoning regulations. And while the sightline issue is not optimal, any changes to what is currently in place to the left would require a dramatic undertaking. With the lack of accident history and low impact to traffic volumes, it may be unnecessary. I request a conditional approval based on the pending approval of the subdivision regulation related to the access way. And he's referring to this 25-foot wide access way because I had explained that we were asking for waivers from that. And also to point out, and this is done very respectfully, but when we came for the, to the ZBA for the variances we need, one of the variances of the zoning regulations was this same 25-foot wide access way. I'm asking you to waive the subdivision regulation. At that time, Mr. Mealy had given a letter of support of that application. The reason I'm bringing that up is because based on various letters of support and approval, Mr. Ward proceeded down the path, spending more time and resources to get this project approved. The other reason I'm bringing it up is that as far as this access way is concerned, nothing has changed since we came in with the variance application. So this lot was proposed back here at that time. The reason we have this is a paving, maybe pavers. This is as a result of many meetings, probably at least 3 to 5 meetings with the fire marshal and revised plans. The fire marshal wanted us, or Mr. Ward, to widen this back access way to at least 16 feet and put pavers down or pave it. And for the reasons I stated earlier, Mr. Ward was unwilling and he's legally unable to do that because it's not his, he doesn't own it in fee simple. There's rights of way across it. So the solution was, the fire marshal wanted a second access, and so the solution was to create this access here for emergency access only. And that's why we have that access way here. But as far as the rest of the plans are concerned, they're essentially the same. It's actually, based on the fire marshal's comments, this is, regardless of the fire marshal's comments, this is staying the same. And Mr. Ward very much wants that land to be the same, and we don't think one additional residence is overburdening an easement. And once again, that's really a decision for a different forum. Thank you.
And continuous the public hearing. The public still has those who spoke recently can just speak with the rebuttal.
I'd like to respond to those comments. Making a left-hand turn from the end of this driveway, the way it exists now, is basically it's a blind corner. It's not visible. Although the police department has not recorded any accidents since 2011, there were also, I have personally seen one in the last 6 months, and have had 2 close calls since then. In any kind of inclement weather, you need to make a right turn. You can't make a left turn. nor is that driveway visible from anyone headed north on Oldfield Road. There's a hidden driveway sign, but it's absolutely not visible. On 2 occasions, my car and an oncoming car have come to a complete stop to avoid a collision in the last 6 months. As far as, I don't know what my rights are as far as an easement, but currently I've given up 1,000 square feet of my property so that the 2 houses, existing 2 houses, have access to that road. But since there is an alternative and there is a paved or bricked road going in that way, I'd prefer to see that traffic routed out directly out onto Gulf Street. A, because it's safer, and B, it's more direct. And I would rather not see any increase in traffic on that road. The existing driveway goes through 4 pieces of private property. If we subdivide this, that makes it 5 pieces of private property, and it's also adjacent to 5 other backyards, within 6-7 feet of 5 other backyards on ranch road houses. So basically, you're affecting about 11 families by allowing that traffic to go that way, and affecting none if you allow it to go left and directly out onto Gulf Street. Thank you.
Does the applicant have anything else to say?
I respectfully disagree with those comments. I don't think we need to go further into it. It's one single family house. I will point out that the 4th house that previously existed was located right around here. So that access way, and the comments with respect to the rights with the access way, it's our opinion, obviously you're not necessarily going to believe me, but it's our opinion legally that we have a right to do that. But that's really a question for a different forum. That's a private cause of action between property owners. That's not the purview of the Planning and Zoning Board.
Any comments from staffs before I open it up for the board for question?
I would take with a grain of salt the submission by Mr. Crusaden of a legal case from the 1920s. Every land use case that goes before the court is different, and there are always different subtleties. So if you use that for a basis of your decision, I would just recommend that you don't. Ultimately, if there is an issue, if this is approved, it will ultimately go to court if someone appeals it, but you shouldn't make a decision based on a recommendation from the applicant that there is case law that says that you have to do something. You don't have to do something other than follow your regulations. And regarding the issues of access, again, your regulations talk about access. No matter how you ultimately vote, if someone disagrees with that, it, like Mr. Crusaden said, will perhaps be decided in a court. So that's all I have to say.
Any questions from the board? Commissioner Sadie?
Thank you, Mr. Crusaden. I got a number of questions for you, please. I'd like you to go through this issue of waiver again. Where in the subdivision regulations is the word waiver used? Just want to find out. You didn't point that out. Just trying to see if we missed it.
The subdivision regulations, section 6.4.
6.4, and it says waiver in that?
It says variances.
I understand. I just want to know where the word waiver is in any of our
Historically, the city of Milford has said that if you're asking for something from the Planning and Zoning Board, it's called a waiver. So I was trying to keep it within the context of what was familiar.
And again, going back to 3.210, the 2 lower lots, as we see on the diagram up there now, you would agree they do or don't have 25 foot of access way. I just want, let's go back to that. Let's do
This right here is the access way coming in off of Oldfield Lane.
Your pointer is not working. That's what part of the problem we have. Either we can't see it from here, or it's not even pointing on the screen.
Okay.
Your pointer. So if you can, the bottom right, bottom left, the 2 orange ones, would that help us? Unless your pointer's working again.
So the question is, do they have 25-foot wide access ways?
Those 2 have 25-foot access.
They have, from Oldfield Lane, no. It's about 12 to 16 feet, depending.
And then when we go down, because we had this discussion last hearing, so the one that's to the bottom left, that's going to go onto Mr. Lynch's client's property.
Yes.
What is the size of that particular road also, or easement?
That's like a gravel dirt road. It's also about, what, 20, it ranges from, varies depending on the location, about 20 feet wide, 15 to 20 feet wide, depending.
Okay, and then, so you would agree that one that goes out to Oldfield is not 25 feet, you agree with that, correct?
I agree that from the basis of Mr. Ward,
Yeah.
from the property line, it's not 25 feet wide, but internally it's 25 feet wide.
And then the one going out is not 25 feet wide, although internally it is.
The one going out is not a subject of a waiver or variance request because it's not a rear lot.
Okay?
So it is not 25 feet wide, but it's also not a variance request.
And then I have to agree with Mr. Sulkus that 1924 case may be insightful, but I'm just wondering why we didn't receive it before the hearing tonight if you felt it was that important.
Well, my experience with the boards is that, number one, you don't need to provide a case as part of a record because it's case law. Number two, we were waiting to see how it worked out with Mr. Luparella because he was raising some of the same types of access questions. And number three, when Mr. Mealy had mentioned it earlier, and I had anticipated that maybe there might be somebody here to speak in favor or object based on an access way, that I would just include it for the record and mention it. But my experience is the board would either defer that question to the city attorney's office, which is probably the most appropriate way to handle it. And I had mentioned it last month, but I didn't provide it, so I thought I would bring it this evening.
Thank you very much. Mr. Chairman, I have no further questions.
Yep.
Any other questions from the board? Seeing none.
I'm sorry, Mr. Chairman, I don't mean to interrupt. I would just, unless the board feels it necessary, you need more information, we'd ask that you close the public hearing tonight. I don't think that you have enough people here in order to approve this application, so we'd ask that maybe the vote get postponed to the next meeting.
Okay.
Thanks.
All right, the public hearing is now closed. Is there any issues with the board on voting this evening, or would you like to postpone it for our next meeting?
I'd like to vote tonight.
I'd like to postpone.
With staff, should we have a...
You have a quorum, so it's up to you whether or not you want to vote on it tonight or postpone the vote.
Mr. Chair, I don't mean to interrupt. The only comment I have, and you can stop me if you want, is that in order for a waiver to be approved under the state statute, a waiver or variance of the subdivision regulation, you need 75% vote in favor of the total members of the board of the commission. So that would mean 8 people would have to vote in favor of it, and I think you only have 7 people here tonight. So if you voted tonight, it wouldn't be technically approved anyway, even if it got approved.
So you're saying, Mr. Crusaden, that that's the same as the special exception rule?
The statute 8-26 says you need 3/4 of the entire membership of the commission in order to approve a variance of the subdivision regulation.
Is that a subdivision regulation, or are you talking about the plain planning and zoning regulations?
Subdivision regulation.
Okay, thank you.
I believe so.
Comments from staff from lighting of the information from...
Well, assuming that Mr. Crusaden is correct, then you would have to postpone the vote. I don't have the statute in front of me to double check. Magically, through the powers of television, I have a statute here which I can go over if you'd like, but I'm assuming that he would be correct.
I'm okay with postponing the meeting until we have a full body commission at this time.
Which subsection was it, Mr. Crusaden? So I don't have to read the whole thing.
I'm sorry, it starts about in the middle of the first paragraph where it says such regulations.
Lo and behold, Mr. Crusaden is correct.
All right, so there will be no vote this evening. And the public hearing is closed, and we'll move on to our next item on the agenda, which is the chair report, which I have none. Our next item on the agenda is the Regulation Subcommittee report, which is Mr. Grant is not here. Our next item on the agenda is the approval of minutes from June 19th, 2018. Do we have a motion to approve the minutes? We have a second?
Second.
All in favor? Anyone? Motion carries. The staff report for this evening?
None this evening.
I have a motion for adjourn. Second? Meeting has been adjourned.